Daily list item number 1.
Your Lordships, I'm praying for some accommodation for today as the senior conducting counsel is on sanction leave. I'm praying this matter may come for after 3 weeks.
The paper book has already been filed in this case, so let this matter come up for hearing.
Submission has been made that the paper book in this case is ready. Accordingly, parties have agreed that this matter may be posted for hearing. Accordingly, list is as such, list this matter for hearing after
3 weeks. Sorry.
3 weeks.
Obliged.
Item number 2.
But this appeal is also already admitted.
Please, this is a judgment. This is an appeal against the judgment and order dated 26/7/2024 pertaining to appointment of judicial officers in the district council. What I would pray is this matter would require some examination by your lordships. Subject to your lordships' kind convenience, if we could have it on a day on which the matter can be taken up for admission hearing.
It's for admission.
This would require, only reason why I say this is, what has happened here is that there were originally 3 posts advertised. There was a list that was published out of for which 6 people were put on, 3 people were appointed, 3 were put on the waiting list. Subsequently, appointments were made, which came to be challenged before this court. Now, the learned single judge has returned certain findings, that your lordships would examine on the touchstone of whatever the law is. Which is why I submit on any date convenient, if your lordships kindly have this for admission hearing, we can assist your lordships with the law on this.
I wonder if there's a similar appeal being filed.
Not to my knowledge,
Not in this matter, my lord.
Not to my knowledge,
My lord, only one aspect before we go further, my lord. Originally, there are 2 writ petitioners, my lord. Now it appears that writ petition number 1 is not interested, he is not filed an appeal. Only writ petition number 2 is filed, the present appeal, my lord. Now, what I understand, my lord, this is a continuation of the original proceedings. So all the parties who were parties before the learned single judge must be represented. But
not petitioners, respondents, yes. My learned friend is correct to the extent of respondents.
What I understand, my lord, and I can place some citations on that all the parties, whether they remain as a petitioner or appellant or as a respondent, but they have to be represented, my lord.
Okay,
here's the situation that petitioner number 1 is totally omitted, my lord, is neither implemented as respondent.
In any case, Mr. Paul has sought for time for hearing on admission. So we will hear issue on admission.
Lordships, why I say this is 5 and 6 are there. These are private respondents who had, sorry, my lords, 4, 5, 6, who had participated before the learned single judge. My lords, notice would have to go to them. Because they would be, my lords, they are the people who are affected. Their appointment has been challenged before your lordships.
Yes, see, before notice is issued,
My lords.
The appeal has to be admitted.
Yes.
We have to admit the appeal.
My lords.
Then cause for notice to be issued. But that stage has not come because you are still on the...
No, what I was submitting before your lordships is probably, which is why I submitted for admission hearing is, my lords, because they are the affected parties. So if your lordships are actually hearing us on admission, my lords, their participation in the proceedings, my lords, in my humble submission, would be necessary. I leave it to your lordships' discretion. If your lordships feel that your lordships would want to hear us first before, my lords, proceeding further, I leave it to your lordships.
You see, in my simple understanding,
My lords,
I may be wrong. The fact is, appeal has been filed.
my lords,
It has to be admitted.
my lords,
If it is found, proper.
my lords.
So once it is admitted, then notice be issued.
True, true, my lords.
Parties will appear, and then the matter will be heard.
My lords.
If there is an issue of maintainability, even so, it would be heard at that point of time.
My lords,
More often than not, this is my personal view.
my
So, and in any case, the matter will eventually be heard. Take into account all the parties are in attendance.
my lords.
So that is the process. But if I understand correctly, what you would wish is for notice to be firstly issued upon those respondent, then
Because
matter
that
comes
is-
up for
that,
admission.
That, my lords, would be, my lords, prior to admitting the appeal, that your lordships would also be within your lordships, my lords, domain to hear all the parties to decide whether the appeal is at all
That
fit
is
for
we
admission or not.
can also do that.
That is for the appellant to satisfy this honorable court. Not for the private.
You're appearing for the
For
private-
one. For one.
That's what I said. That's what I was saying. I think my brother is also of the same view. Will, without admitting the appeal, will not issue notice.
As your lordships may feel appropriate.
So we'll take up the hearing,
As your lordships may feel appropriate.
admission. Thereafter, naturally, notice have to be issued.
If once your lordships admitted, then notice will definitely go.
So when do we have it, Mr. Paul?
Convenience of your lordships, my lords, this week or sometime next week, my lords, subject to you.
On pre-made by Mr. K. Paul and counsel seeking some time to be heard on the issue of admission of this appeal. Matter is adjourned. This is after 1 week.
A week.
Item number 4.
Yes, Mr.
Please, Your Lordship. These are two appeals, item number 4 and 5, challenging an order of the learned single judge dated 5/6/24. This relates to the standard table of rent which was drawn up by the cantonment. His Lordship Justice Bhattacharjee had the occasion to deal with another matter.
That similar order, your lordship.
So the question is whether your Lordships would take up this matter.
Any matter decided by
Lordships have not really decided. In fact, Justice Thank You had passed an order, and Lordships have, on the basis of that order, dismissed another appeal. I apologize, two writ petitions.
Appeals have been filed against that also, my lord.
then it may not be proper.
My lords. In the other cases, His Lordship Justice Thank You is recused. So,
You'll have to wait.
Lordship.
Not take-
So I'll leave it up to Lordships.
No, it's nice that you have pointed out.
So what do? Then I sit here on my own, and then I switch sides there. Then make two of me. This is a peculiar situation we are having. Only here. This is matter before any other bench except without Justice Bhattacharjee.
I'll leave it.
So that's
Both the items, my lord. Item number 4 and 5, similar orders.
4 and 5.
4 and 5.
4 and 5.
Obliged.
Same order.
Item number 6.
But how would that have? Yes.
My lord, this is for hearing, my lord.
Yes, Mr. Dev.
Lordship, I pray for time, Lordship. 3 weeks, Lordship. I prefer 3 weeks time, Lordship.
The law is on your side. You're still praying for time.
My lord, this is a matter where we are still on the bail stage, my lord, something like that, and final argument is final hearing of the trial. Trial is about to conclude. My lord.
We are also of that view.
Right.
You see. We are only on that issue of
Interim,
that,
interim release, my lord. Yes.
question of the period.
My lord.
But then, as far as the trial is concerned, that will go on.
Separate issue.
Our trial is about to conclude. My lord. It is only a matter of final adjudication. Only.
Really. So it doesn't matter where the material is.
My lord.
If it belongs to you, it will come back to you.
Yes.
If he wins in the trial, my lord, we have to give it back to him.
You're taking a chance to get this matter kept in abeyance. When do we have it?
After 2-3 weeks.
Lordship, after 6, after 3 weeks.
3 weeks. On prayer, Mr. P.Deb, Learned Counsel for the respondent, has sought for accommodation on the ground that he is not prepared to be heard on this matter today. As prayed for, this is matter of the 3 weeks.
Daily list, item number 1.
Yes.
This may please my lord. My lord, I beg to withdraw my application with the liberty to file a fresh one under the new act.
Would there be a difference if you do so?
Lordship, he is the master of proceeding.
You could have just made a prayer for amending this petition.
Lordship,
It's
as I have submitted.
It's just a question of the applicability of the new act. That I think I've decided.
Lordship, yes, in that Balmiki Suna.
So, Mr. Sharon?
Your Orders, I beg to file with the liberty to file a fresh one under the new act.
Fine. Mr. Sharon, learned counsel for the petitioner, has sought liberty of this court to has made a prayer to withdraw this petition with liberty to file a fresh one. Prayer law. Petition is dismissed as withdrawn with liberty sought for allowed.
Apply, Your Lordship.
Much obliged.
Item number 3.
Please, Your Lordship kindly allowed me to withdraw this bail application.
NDPS,
Yes, Your Lordship.
commercial quantity, intermediate.
Intermediate.
How long? Who's in custody?
There are 3 people in custody,
people,
but
yes.
he's moved for one lady.
Gracie.
Gracia.
Yeah.
This is not the first bill application.
This
There
is
was
the
one which they withdrew, Your Lordship, because of some defect. Then now this is the second bill.
Yeah, this is the second. Yeah.
Same order, no? Fine.
Pleasure.
Item number 4.
My lord, I am appearing in item number 4, 5, and 6.
Yes.
These are all connected matters. This is the bail application, my lord. The other day, I had withdrawn because the
May it please, Lordship. Lordship, in terms of the last order, Lordship, we have taken steps on respondent number 2, Lordship. Because
no report,
Lordship. We'll be filing an affidavit, Lordship, bringing on report because the
notice has been affected.
Lordship, we have taken steps, Lordship.
Taken steps, but according to you, has notice been affected or not? So we have to await.
Lordship, await. We have to await, Lordship.
Who is the respondent to?
Lordship, state. Not sure, Lordship.
Number 2 is
West Bengal, Lordship.
West Bengal.
Lordship. It's a formal party, Lordship, otherwise. Lordship.
I think this court has expressed some view, rather have tried to elicit a response from the parties as to what is to be done in such circumstances. Because this is basically transit bill. Transit bill more often than not would not be opposed.
Absolutely, Lordship. Hardly anything.
In terms of the judgment of the Honorable Apex Court in these matters, what the Honorable Apex Court says that, well, as your Lordships rightly said, it would be a transit bail. But that would have to be passed only after hearing the prosecution of the state concerned.
Is it so?
Priya Indore, I had the occasion to appear in that matter before the Honorable Supreme Court. That's a reported judgment on this issue of transit bail.
It's a reported judgment, Lordship, yes.
They say, Malaj, because what had happened in that matter also,
The
matter of Rajasthan, Malaj, a court in Bangalore had granted bail. So what we had said is, Malaj, the prosecution is initiated by the state concerned where the FIR is registered, not where the bail is sought. So even though, Malaj, the public prosecutor of the state where the bail is sought, Malaj, would be there before this honorable court, but your lordships will then exercise powers, Malaj, only after hearing the prosecuting agency.
I don't know. See, that would be with regard to regular bail.
Malaj, on transit bail. That entire matter was only with regard to transit bail. The question that fell before consideration was, Malaj, whether under 438, your lordships would have the power, Malaj, to grant anticipatory bail at all in the first place, because there were conflicting positions. So now that's been settled, Malaj, that your lordships can issue transit bail, but that would be only after hearing the prosecuting agency concerned.
So, you see, the other aspect would be, what prevented you from, appearing before such court, seeking pre-arrest bail and so on?
Well, in this case, the petitioner herein is a resident of Shillong. The incident, Malaj, happened in Shillong. The series of FIRs, Malaj, filed both in West Bengal and in Sikkim.
No, that is okay.
Malaj, where they threat to the life of the petitioner concerned. Malaj, that's all on record.
True. That is so. But the fact is that similar cases have been registered in those courts.
Outside, all registered in West Bengal, Malaj.
So, if that is the case, then
my difficulty is, Malaj, that I cannot go to West Bengal without any protection from your lordships of transit bail, only because, Malaj, there is a threat to my life, and it is there.
Even if on the issue of threat,
Malaj,
that could a case could be made out before the concerned court.
To go there and appear before the lordships, Malaj, that would be there. Malaj, if I am taken there, Malaj, because these allegations, it's not by individuals, Malaj. What has happened is organizations have come out and made threats, saying that if you are seen anywhere in these areas, Malaj, this will happen to you. Somebody says, Malaj, you will be killed. Somebody says your face will be smashed.
I don't think the situation would be that the law would not take care of, or the courts for that matter would not take care of.
Which is why we are before your lordship, Malaj, with the limited prayer that to grant me transit bail to enable me to go and seek my remedy before the courts concerned. Because there's considerable public pressure that's created on the police there, Malaj, insofar as this particular matter is concerned.
See, Mr. Paul, what happened is, now we are on this only on the point of issuance of notice, or rather,
here your lordships have already issued notice, my lords. Yes, lordships have also protected me in the interim. My lords.
But what happened is, you are stuck here. You are practically in a limbo, because
correct, my lords.
Finally, you still have the one way or the other.
If
you
your
still have
lordships
to
just permit me a second, my lords. My lords, what I'm instructed is that they had taken steps initially, my lords. It came back unserved, which is why your lordships directed to re-service.
Exactly.
You have taken steps too. Well, it's what I would pray is, if your lordships permit us, Millards, we'll just find out the status of, Millards, whatever is the status of the notice which has now been sent.
That you see, that I can grant you time.
Millards.
It's not a problem.
Millards.
What I am trying to
It cannot be in a limbo. Your lordships are
what
correct,
I'm trying
Millards.
to say is that you're just delaying the inevitable.
No, Millards, if your lordship so feel, Millards, that if a limited protection be granted to me for a limited period of time to enable me to approach that court, Millards, that would suffice.
See, now you're citing a Supreme Court judgment which
Millards,
says
because
otherwise.
Millards, I'm obligated to place the law before your lordship.
Exactly.
And that's the correct position of
I'm obligated,
So,
Millards.
so that is why we have to go through the
And
process.
especially since I'm aware of it, Millards, I cannot not bring what the law is before your lordships.
So we'll wait for the notice part to be over, Lordship, and then.
That's what we have to do. But Mr. Learned Counsel for the petitioner who has submitted that the notice issued upon the respondent 2 has not yet been affected, since no indication has since there is no indication either from the post office or by way of communication to this court, to the registry of this court. It is prayed that the service report may be awaited. Pray aloud. The petitioner would also do well to ensure that to file necessary affidavit of service if confirmation of such service is made known to him.
Reading the judgment.
What about the other respondents, Mr. Port?
I'm sorry, Millards.
What about the other respondents?
Other responses, sir.
They have all served.
All served.
I have only responded of one, Lordship. State of Meghalaya is 1.
So it appears that 3 and 4 are
Millards,
SP of Kalimpong and
Kalimpong, Millards, and Darjeeling. They've been served, Millards.
You have issued, have you filed affidavit of service?
Affidavit is filed, Millards.
Okay. On pre-made, this is matter after 2 weeks. In the meantime, the interim protection given to the petitioner would remain in force until the next returnable date.
Obliged.
Obliged.
Item number 8.
Millards, I'm instructed 2 queries had fallen from your lordships on the last occasion when this matter was listed before your lordships, Millards. Where's the last order? When the matter was listed, Millards, on 27/8, Millards, some queries had fallen from your lordships regarding, Millards, as to where is the apprehension of the petitioner insofar as arrest is concerned.
Okay.
Here, Millards, what had happened is there is some FIR which was filed in the state of Maharashtra, Millards, in Bombay with regard to some child trafficking issue. Some 2 people, Millards, who had sold their child to somebody had subsequently, Millards, gone and filed some FIR. On the basis of that, some investigation has been initiated. Now, the sister-in-law of the petitioner, Millards, who is a resident of Hyderabad, because that FIR mentions Hyderabad, was arrested in connection with this particular case. And Millards, our case before lordships is that her daughter is married in Shillong, so she's all along been in Shillong. During the period when that incident happened, also, Millards, we've shown documentary proof that we were very much in Shillong. We have been getting repeated calls, Millards, from the Mumbai police, from Hyderabad, saying that, Millards, that you are required in connection with this case. Even though I have nothing to do with it, Millards, I have been in Shillong. I stay with my daughter. Now, this had happened. Only thing is, Millards, that it has not come out in the pleadings. If your lordship so permit me, file an additional affidavit bringing the records of those phone calls and those messages on record, Millards. We have stated in our paragraph, Millards, paragraph 4, if your lordships kindly see, Millards, at page 6. Well, as the petitioner states that in connection with the said case, she so-and-so, who is the sister-in-law of the petitioner, has been arrested from so-and-so by a team of Mumbai police on 3/7/2024. It was at that stage, my lords, that this anticipatory bail application had been filed before your lordships. Of course, my lords, thereafter that other issue was to be decided, so this matter has been delayed a bit. And the matter has been kept pending before your lordships.
Is this also an issue of a transit bail?
Transit bail, my lords.
Has the issue of as regard notice been settled?
My lords, your lordships are yet to issue notice in that matter. This matter was, my lords, because it was stuck because of whether it is to be under BNSS or CRPC.
So
We had filed it under BNSS. Let notice issue, my lords.
Notice has to go, my lord.
Let notice issue.
Mr. Sincon, you will be appearing for respondent 1.
Yes, my lord.
One and, yeah, only one. 2, 3, 4, my lords, will have to take steps.
Heard Mr. K. Paul and Senior Counsel appearing for the petitioner. The respondent 1 state is represented by Mr. N. Sincon, Leonard G. However, as far as respondent 2, 3 and 4 respectively are concerned, Mr. Paul would submit that notice may be allowed to be issued upon such respondent before this matter is heard. Pray aloud that notice be issued, returnable within 2 weeks.
Well, I'm obliged.
Obliged.
Item number 9.
Taken steps upon the private respondents, and
My lord, report from the IU, my lord, is here.
It's a POXO matter.
My lord.
POXO.
So we have to wait for the, what do we do? We still have to wait for the appearance of the...
My lord, notice has already been served to the victim, my lord. Complainant as has been informed by the IO.
I've taken steps through the IO. My lord, I've just been told that they have received, but then, my lord, they are not represented
What they
today.
have received?
That they need to be heard.
It has been served through the IO, my lord.
Yeah, but there must be some...
Yeah, yes, my lord.
There must be some, at least...
Acknowledgement.
Acknowledgement by way of receipt or by way of in a report file.
That is not...
The IO has filed report that notice has been received.
My lord, that is not included, my lord, in the report.
I can file an affidavit to bring that on record, my lord.
Even otherwise, my lord, the 164 statement of the victim, my lord.
This is anticipatory bill.
Yes.
Anticipatory bill, my lord.
But I have flagged the 164 statement of the victim, my lord, if my lord will go through.
Where is it?
My lord, it is flagged, my lord.
You don't have a copy with you?
My lord, I have a copy, my lord.
So you lead this court to the statement?
Yes. My lord, the statement reads as follows, my lord. I am the fourth child among 7 siblings. My 3 elder siblings are not in the village as they are working and studying in Shillong. My youngest sister is with my elder sister in Shillong. So at home there is just me and 2 of my younger brother and my parents. On 28/7/2024, it was a Sunday.
Yes, what is this?
Lordship, the
Please, Your Lordship.
Oh.
Your Lordship, this is a matter. Am I audible, Lordship?
Yes, yes.
No, this is a matter where they have filed an application for impleading, and Your Lordship has heard the matter. The only query left from Your Lordship was that to produce the amendments made in the writ appeal before the division bench. Whether the inquiry has been challenged in the division before the division bench.
Just a moment, Mr. Nongri.
this case number 115.
This missed case number 115 is for?
This is for impleading.
Impleading. Okay, okay.
If Your Lordship recollect, they are not a party to the proceedings.
Yes, yes. So we'll hear this matter. Why? Oh, Mr. Sangrisu. That is as far as this missed case is concerned. Then in the main case, the respondent 5 is to file the counter. Who's respondent?
Not yet.
Not yet filed, my lord. I pray for some more time.
The other respondents have filed?
Your Lordship, we are highly prejudiced because inquiry also is going on.
But what do we do, Mr. If there's a prayer on personal difficulty?
I totally understand, but if Your Lordship understand that if the inquiry is suspended for a time being,
in any case, I think,
greatly prejudiced, Lordship.
Mr. Nongri, I believe, I don't recall, but I think this court has passed an order that the
yes, or Your Lordship, in fact,
the proceeding would be subject to the outcome of this petition. Is it
even
so?
though, Your Lordship, even though, because it's for the ends of justice, if it is stayed, Your Lordship, then whatever the outcome of the writ petition,
Stay at
it
this
has
point
to
of time.
proceed, will proceed.
Stay at this point of time will not be proper.
Because Your Lordship is well aware what are the procedures, how proceedings is to be conducted. In this matter, Your Lordship,
If the authorities so chooses, they can do it as soon as possible, as expeditiously as possible. So they will do it. And in any case, the final outcome will not be published until this petition is disposed of. So it will not prejudice your case in any manner, because that matter would be kept under wraps.
Your Lordship may make observation that the report should be under seal cover.
Ini ke biskit semua. Mr. Land Council for the applicant or petitioner. For the applicant has submitted that some time may be allowed for this petition to be heard on the ground that Leonard Senior Counsel who is conducting the matter is indisposed on ground of personal difficulties. On pre-meet, seems allowed. So we'll wait after 1 week. This is matter after 1 week.
Lordship, after 1 week.
1 week. Main case. Ms. Angela and her counsel for the respondent number 5 has sought some time for filing of the counter affidavit on the ground that the same is not prepared. Has not yet been prepared. Pre-allowed. On the prayer of Mr. P. Nobril and counsel for the petitioner seeking a stay of the proceedings before the concerned authorities, that is the KHADC, as far as the inquiry is concerned.
No, Lordship, it's before the inquiry officer.
Sorry, before the inquiry officer, as far as the said inquiry proceeding is concerned, this court, as has been observed earlier, is not inclined to do so. However, it is reiterated that the outcome of the said inquiry proceedings would be determined only after disposal of this petition. However, in case the said inquiry proceeding is concluded before this instant petition is disposed of, the related or relevant report or findings would be kept under seal cover until such further orders by this court. That's it.
Obliged.
Break for 2 weeks' time, Lordship.
Makes no difference because the order is already there. 2 weeks.
2 weeks, Lordship.
2 weeks. Okay, I have to go. But I have all these. The other is for 1 week.
1 week, Lordship.
Lordship.
Try to do it more.
I'll try, my lord.
We'll see how it comes.
Lordship.
But I would also like to dispose of the others because that would have a bearing in the, you see, as far as the main petition is concerned, whether the applicant is to be impleaded or not.
Lordship.
Once we are done with that, then we can proceed with the.
Much obliged,
So
Lordship.
1 week.
Much obliged, Lordship.
Item number 11.
Yes, Lordship. On the last occasion, Lordship, my senior counsel, Sir Depnat, was entered appearance for Miss Case, Lordship, item number 11.
So, Your Lordship, today I got the copy, Lordship. Let me
What's the,
sometime
just a moment. Where's that Miss Case? Miss Case? 121. Oh, this is for those.
Yes, sir. Impleadment, yes, Lordship.
Those have been appointed in place of. Okay. So you have to file your counter.
I'll file my objection.
Objection to what?
For implement.
You are the incumbent, present incumbent. You have been appointed in place of the petitioner who have since been terminated, whose service have been terminated, isn't it?
So, Your Lordship, here in this case, they were terminated, and some cases they have restated, but they are not joining.
No, we are. Let's take one case at a time. Let's not be confused. As far as this case is concerned, do you still have objection of being impleaded?
So, Your Lordship, because I should bring the facts how I have been appointed first.
Yes, that you can do it in your counter. You have to file your counter. If you are not in the case, then you see, any order can be passed against you, even an adverse order. Order passing. Yes, you have already entered appearance.
Yes, Lordship.
On last occasion, yes.
You only to file your power. Have you filed a power?
Yes, sir, I file.
So we'll dispose of this petition. Heard Mr. Artevna, Leonard Counsel, for the respondent 6 who has submitted that who has entered appearance and has filed his power as regard the said respondent. Accordingly, on hearing the parties, this court is inclined to accept this to allow this petition. The respondent 6 is accordingly read as the newly as the respondent 6 in the main petition. The petitioner is directed to take steps for correction of their cause title. Mr. Atamra in the meantime has submitted that he may be allowed to file his counter affidavit. He may be allowed to file the counter affidavit on behalf of the said respondent, newly impleaded respondent number 6.
In this case, purpose the writ petition to be given, only miscellaneous application they given.
So that is as far as impleadment is concerned.
No, item number 121.
That is 121 dispose of.
In 5 matters they have filed impleadment, in the other 2 there are 7 connected matters. So in 5 they have filed impleadment.
Mr. Devna, are you appearing in all those?
All 5 I am appearing. All 5.
Okay. So same order will follow?
Same order will follow, yes.
Respondent number will be different. Respondent number will be different.
Okay, we'll just check the respondent number and
Yes,
we'll make correction. Mr. Devna, you are appearing in which you said sometimes because there are so many matters, it becomes very confusing. In item 11
The respondent 6.
Respondent number 6.
and 12,
Respondent number 6, Lordship.
Mr. Devnath, are you appearing in 12?
Yes.
But you said all 5. Now 13, she is appearing.
The last seat as interpreters are correspondent number 6 and 7, since they have already impleaded their retired SEO.
Oh.
Waiting for some time to file that.
Okay, so this item number 13.
Yes, Lordship.
You have impleaded the retired principal
Already,
and
yes, Lordship.
SDO.
Yes, Lordship.
The present principal and retired SEO.
Present principal. Yes, in their individual capacity.
Yes, sir. This case now.
Okay, you file your response. Mr. Learned Counsel. Appearing, you have file your power. No, you see, first you have to enter appearance, then you can file your response. But the question is, without entering appearance, without filing your power, you cannot make submission. So the query is, you are making submission on behalf of the respondent 7 and 8. Is it 7 and 8? 6 and 7. 6 and 7. So have you filed your? Mr. Learned Counsel has submitted that as far as respondents 6 and 7 are concerned, she would be appearing on their behalf. However, the power could not be filed today and has sought for time to file the power on the next date fixed and to file a response to this petition if so advised. You file your power, file your response on the next date. Then as far as respondent 8, as far as respondent 8 is concerned, Mr. Devnath has entered appearance and has submitted that he has no objection to being pleaded as party respondents in the main case, but has however submitted that he may be allowed to file his counter affidavit on the next date fix. Accordingly, to this extent, this petition is allowed. The respondent aid herein is now impleaded as party respondent in the main case. Petitioner to take step for necessary amendment of the cause title. That is 13. And then 14.
14. You are appearing for respondent 6.
14, 15.
I am for the respondent number 6.
6. So the same order will follow as the earlier order. Item 11, same order. That is in 14 and 15. 14, 15 also, Mr. Debra?
15 is representative for respondent number 7, if I am not mistaken.
I am for the 7.
Fine, 7. So we'll just change the, the numbering.
All the cases, Your Lordship, copy of the request.
Yes, please do that. Then what else? 16, 17?
We didn't file any keeping.
No miss case.
No miss case.
Because different.
This is only for salary.
No, for termination.
For salary, yes.
Yeah,
last two items.
Last two items for salary.
Not exactly, sir. There is a document, there is a fake document being given to the government for the appointment. That is the issue in this argument.
No, but have they been, what is the case of the petitioner? That he has been terminated?
My lord, he has acquired the service on a document which was found to be fake, my lord. So now the roll number, everything was sent for verification. It was found that certificate belongs to someone else, which is why he was terminated.
So what action was taken?
He was removed.
Removed. So it amounts to termination?
Yes, sir.
So?
I don't know whether someone was appointed or not. Since they have applications.
I'm not aware of this case, Lordship.
The prayer of the petition in that case is to release the area salary.
Area salary.
My lord, these matters were not heard because it was sequentially heard, so subsequently when it will become, the entire picture will be clearer. Because Lordship has heard the first two matters on the last two occasions. Then this Impleading application is coming to the manner. So subsequently, Mr. Sheikh will be in a better position to explain the entire issue.
Actually, the matter has been heard in all the matters. But again, during the time of hearing, this whether the
that issue of impleading of impleading of the newly appointed incumbent has come.
Yes, Your Lordship.
I think this 16, 17 has to be clarified, but you are not in a position to say anything.
Yes.
So we'll can issue a main case list 1 week.
My lord can have this particular two matters coming days so that the clarification can come, and if there will be a requirement for this case or not, that can be decided. And once it's decided, all the matter can come again together. Only for this, because the first 5 matters have been cleared out.
Okay.
So this can be done in the 1 or 2 days, so she shall list this matter.
As far as the other matters are concerned, we'll list it after 2 weeks.
Let me 3 weeks, Your Lordship.
Why 3 weeks?
Because
matter
they
is
will
already,
give the copy and then after that reply.
it's already an old matter, Mr. Debra. It's a 2018 matter.
Your Lordship, I have to have the copy and after this I have to prepare my reply also.
But see, be sure to file your counter because this court will not, allow further time. On pre-made by Mr. Devnath, matter is listed after 3 weeks. 16, 17, where? List is matter. Where is Mr. Sheikh?
It's on the next court.
On next, my lord.
So tomorrow we'll take it up?
Tomorrow. Okay.
We'll take up this matter tomorrow. This is matter tomorrow. 16, 17, no? So tomorrow.
Item number 18.
Wait, please, Lordship. Lordship, in this matter, Lordship, I'll require 1 week's time, Lordship, because the reason that, Lordship, on the last occasion, your Lordship has indicated that both the appeal and remission cannot be cannot go simultaneously, Lordship. We have to choose one part, Lordship. So we have informed the client, Lordship. So they will inform us, Lordship, whether to proceed with the remission or to go with
what
the
revision is there? This is the appeal.
Lordship.
Then where's the revision?
Lordship, that's what, Lordship, like we have informed the client, Lordship, they were of the view that they will be filing for remission. If in view of that, Lordship, the appeal cannot go on together, Lordship. Your Lordship on the last occasion has indicated this, Lordship. So to that effect, Lordship, I'll need some time, Lordship, because I've informed the client.
On prayer made by the appellant, land counsel for the appellant seeking accommodation, that is adjourned. This is here after 2 weeks.
Hello.
Item number 19.
This matter, we're still in the process, that we have some positive instructions insofar as the efforts by the parties. I was just talking to my learned friend also, we are trying to push them if hopefully something comes about.
Some settlement can be come into it.
What is this matter about?
It's a revision against an original suit had been filed. The dispute is with regard to an approach road that both the parties have. So it's basically a question of somebody ceding some feet in width.
Where is the Sudland situated?
Bhagyakul. We are trying to persuade them, whereas we've examined the matter. That does not seem to be one of those matters that really needs a trial. Of course, it's seen the trial court, appellate court, and now you're before your lordships.
Legal counsel for the parties have submitted that even at this point of time, parties are still trying to find ways and means to settle the matter amicably, and as such the prayer made by the party by the legal counsel is for this matter to be adjourned for the time being. How long?
After 2 weeks.
As prayed for, this is matter after 2 weeks. I'll not comment on whether you come to a settlement or not. That's up for you to decide.
Yes. We've explained to them that this matter may not be beneficial to anybody. It may be in everybody's interest that this matter is closed.
Fine.
Right.
Item number 20.
Wait, please, Your Lordship. This is that university matter, it was listed with the analogous matter. Some of the cases has been disposed of by Your Lordships. I think against one judgment and appeal is pending. But anyway, my lord, this writ petitioner is dead, my lord. He died during the pendency. So this is the situation. So unless substituted, my lord, I think it's more than 3 months onward. So it's already otherwise stand awaited. Last year he expired, my lord, 6 months. So he stand awaited, my lord. Perhaps Lordship wants to indicate, my lord, one thing, just saying that Nehu may consider. My lord, there will be a problem here. If this person is dead, court cannot pass any order, my lord, in this case. So, my lord, unless they, my lord, legal air comes.
But see, Mr. Sen, on the other hand,
Lordship.
let's assume for a moment that this matter is over and dead. Now, if you see at the relevant point of time he is found to be entitled, so naturally his nominees would get the benefit.
No, that I understand.
So-
Human aspect, that definitely.
No,
Some
no.
legal years comes.
Yeah.
One thing I was expecting, they will come here,
No.
and then Lordship will dispose of the matter. So suppose Lordship is closing this matter, because otherwise nobody is before your Lordship. Now tomorrow somebody comes before the university, legal years, and if they make a request, this is the thing. Definitely we are bound.
Exactly, because you see, if I understand correctly,
Lordship.
this case
Depending on others.
is dependent on the disposal of the other related case. So if all the other cases are disposed of, so nothing remains here.
Nothing.
The university authority will decide as to whether he is entitled to or not. Then, if now that he is dead, his legal heirs will naturally get the benefit.
The legal aid comes. The only thing, my lord, I'm sorry, my lord, I do not want, like, technically it is like, my lord, person is dead, my lord. Otherwise, if they come before the university, I don't know whether, Lord, definitely
We are
are
not
bound.
talking about this
But
case.
only thing I am pointing out, my lord, just like a suit, my lord, if that unless substituted after 60 days stand awaited, no order can be. So these also, my lord, technically stand awaited, your lordship.
But it's
That is the, but of course, lordship, what is that human aspect? Definitely somebody legal yes. Who is the legal yes? I do not know.
We
my
don't
lord. If they come through proper purposes before the university, seeking a consideration, university is under obligation, because the university's order is that we could not consider at this point of time.
Exactly.
Similar issues are pending. Now that I understand. The only thing I am pointing out, my lord, so far this proceeding is concerned, my lord, if they had substituted, my lord could have closed the matter with the direction, go back to the university.
We could
But
do
only
that.
thing is this, my lord, the legal years are not before this court.
Why?
Your Lordship will take instruction, Your Lordship, from the family members of the
That you have
deceased.
already, you see, I think that was a common refrain for you. Every time this matter comes up.
Yes, Your Lordship. Your
Is there
Lordship,
any problem with the family members?
Your Lordship, we haven't received any instruction. We have already informed the family.
Nobody is interested in money.
Your Lordship, 3 weeks time may be allowed, Your Lordship.
You see, as Mr. Sen said, the procedure is this: if you are not and this court has been lenient enough to give you time, considering the fact that the petitioner is since deceased. But that would not be an excuse for you to lack. You should be prompt. Either you come with a definite, submission before this court that matter is over and done with as far as this petition is concerned, or the legal heirs would like to be. You do that.
Yes, Your Lordship.
On the other hand, as Mrs. Sen has has opined, I would say, if the legal heirs, if there are legal heirs, at any point of time they can always claim the benefit if he is really entitled to. That is also an option for you.
Yes.
Mr. Counsel for the petitioner, deceased petitioner, has submitted that till date no specific instruction has been received from the legal heirs of the deceased petitioner as far as substitution in this petition is concerned. Accordingly, it is prayed that some more time may be allowed in this matter. 1 week.
2 weeks time, Your Lordship.
Accordingly, as prayed for, this is matter up to 2 weeks.